So hello, my name is Helen Slottje. Thank you all for coming here today. Thank you for the Government Law Center for hosting this event. And my apologies for Deb Goldberg, who was unable to make it today, and we'll be wearing both hats in that sense, covering her presentation and mine. In your books, there are some materials that I had put together. Those are simply for reference. I never intended to go through those. Deb put some slides together, and I was contemplating using her slides, but that's just going to screw me up. So I'm not going to use her slides. They are terrific and will also be a good background. As far as who I am, who Community Environmental Defense is, the company that I work with, I didn't go to school here. I went to University of Pennsylvania and Harvard Law School. I've been practicing for 20 years. And Community Environmental Defense Council is focused on protecting community rights and community property. And our primary clients are municipalities that are seeking to protect their community character, their way of life, and the things that they value about their communities from industrial resource extraction techniques and the like. So we've been working on this exclusively for about 3 years. 2 years ago, we began to promote the concept of using local land use laws to prohibit gas drilling or high-impact industrial uses as not a regulation of the industry, but as an exercise of land use powers. And so there are those two models out there. The town of Middlefield, in the Middlefield case, they use the high-impact industrial use model. The town of Dryden used the outright prohibition on zoning, using zoning to outright prohibit gas drilling activities. We too do not suggest that any community enact a law that specifically references or is directed at hydrofracking. We believe that is an operation and process of industry and would not suggest that a community use land use powers to ban hydrofracking per se. We believe high-impact industrial type activities, resource extraction, gas drilling, but not focusing on hydrofracking itself. So this position that we've been articulating and advocating for has been adopted at this point by over 100-some municipalities in the state. We've probably worked with close to 100. There's a number of communities still working on this. There are communities that have used their own lawyers but have followed our models. There are communities that have gone out on their own a bit. Some of those do not follow our particular recommendations, but there's, all told, a great number of communities that are looking to try to protect themselves and their community character. So the two Supreme Court decisions that you've heard about in Middlefield and Dryden both completely upheld the community's rights to explicitly prohibit, in one case with high impact and the other using zoning, gas drilling. So all of the arguments that industry has, in fact, and Tom West today has presented to you were explicitly rejected. And while there's some reference to those being politically motivated or local decisions, the Tompkins County decision, the Dryden decision, was made in Cortland County by a Cortland County judge, a Republican judge, an ex-Marine. And the Middlefield Cooperstown case was referred to Madison County and was also made outside of that particular county. So you have two different judges in two different counties reaching the same conclusion, that communities have this right. So, and they have not yet been actually appealed. As Mr. West noted, they have to file both a record and their briefs. That has not happened yet. There's the prediction that that's going to happen, although we're now several months after these decisions. And if I were industry and if these were such terrible decisions, I would have appealed by now, I think, or done at least made some more progress. In fact, Mr. Westwell today, he's talked about his hopes of prevailing. In June, noted that it would be a tall order to prevail in these cases. So, and we believe that to be the case. We agree with Mr. West's earlier assessment of his case that this was going to be very difficult to overturn these two decisions on appeal. So turning to the statute, and I'm going to just use these same slides because we're looking only at the four corners of these documents just as well. So when you're looking at the mineral mining statute, which is this one here, so when we started looking at this, we said, well, what is relating to the regulation? What does that even mean? And so when you go and look in court cases in New York State to find out what the word regulation means, you do wind up back here. The only cases that have interpreted what regulating an industry means are cases that have interpreted this statute. And so when you read a statute, semicolons are very important. Basically, what the first half of the sentence before the semicolon, that's called the enacting clause. That's the circle of activities that are included in whatever the statute's talking about. So here it says, this article shall supersede all state and local laws relating to the extractive mining industry. So that's your circle. Then you carve out of the circle what is accepted. But you can't make the circle any bigger with your exception. An exception cannot be read to expand the circle. So here the exception is that nothing is going to prevent local governments from enacting laws relating to mine land reclamation. Mine land reclamation is an entirely different subject from mining. They are two separate things. So the mine land reclamation exception here, talking about zoning, has nothing to do with the first half of the sentence. So it's basically saying for mining industry, you can't pass any local laws. Read it as a period. And for mine land reclamation laws, you can enact local zoning controls. And the courts interpreted this originally in Frew Run, and in fact, the court said yes. Relating to regulation is operations and processes, it's not zoning, it's not land use authority. And when they went and amended the statute later, this was not an amendment that simply codified the Frew Run decision, because industry, the mining industry in that case, didn't like that decision. They didn't like communities having absolute zoning control. So this legislation, the amended mine land reclamation law, limits the holding in Frew Run and says you can have some zoning that relates to the mining industry itself, but only on a few things. You can regulate this, that, and the other thing, but you can't regulate anything else. So the amendments to the mine land reclamation law are really not particularly appropriate. So we go back to the mining law, the case in point here. So you read the first half. What's in the circle? What is prohibited? The ordinance is relating to the regulation of oil, gas, and solution mining industries. That's the circle. The semicolon and everything after it, that's a limitation. So, and an exception. That cannot make, again, that can't make your circle, the first half, any bigger. So only local laws or ordinances that relate to the regulation of the industry are excluded. The exception, in the event that your local road ordinance might focus or target the gas industry, or you would focus and target and regulate the industry through your assessments, that exception only takes out of the circle. It doesn't make the circle bigger by accepting things out of the circle. So we believe that when you look to relating to the regulation, you can look at these mining cases that interpreted what that meant, and that land use decisions and environmental regulation are two totally separate spheres. There's some cases cited in my materials. There's a U.S. Supreme Court case that talks about the California Coastal. And in there, the Supreme Court finds that basically environmental agencies are regulating how much you get to pollute. They decide what amount of pollution is permissible. That's their job. That's what they're doing. The community makes local land use decisions. They decide whether they want that polluting industry in their town in the first place. And when you talk about preemption and whether or not this statutory scheme here, the fact that the state permits an activity, provides a permit, provides some sort of regulation of that industry, that is not a land use decision. Those are totally separate. And in New York State, when they want to take away a local government's land use authority, they know how to do it. Deborah has some slides to talk about this. There are very specific statutes that do take away siting authority, and they say it explicitly. There has been no need in New York to search for implied supersession of zoning powers. And in my materials, there's some discussion about You can completely prohibit an industry. You get all sorts of permits, you know, occupancy permits, this and that, food licensing to operate a hotel. You can prohibit a hotel. You get permits and the like through the Bulk Storage Act, Petroleum Bulk Storage Act. You can prohibit bulk storage of petroleum in your community. State has regulations for dumps. You can prohibit dumps. So the fact that the state authorizes a permit does not invoke this conflict preemption. Even if conflict preemption applied, the courts have said that this conflict between your zoning and a state permit is not the sort of conflict that anybody's talking about. So conflict preemption basically doesn't apply in this instance to zoning type rules. Furthermore, while industry proponents might like for the concept that you don't search for implied preemption when you have express preemption to just be maybe you do that, maybe you don't, both the Frew Run and the Granite Asphalt cases, ones that interpreted this mining law, specifically say if there's an express preemption, you don't make it any bigger. When the legislature wants to expressly preempt something, that's all you do is you read that language. You don't go searching for more reasons and other ways they might have wanted to preempt. If they explicitly preempted it, end of story, all you do is read this language. So we believe that, again, the preemption arguments are not particularly persuasive. They're not persuasive at all. There's express preemption here. It doesn't talk about zoning, and there's no need to look for implied or conflict preemption. When you look at the policies of the state, and we've talked some here about the state energy policy and policies in the Department of Environmental Conservation statute, there are all sorts of policies in the state of New York. These aren't the only two policies that we have. There are constitutional policies of protecting the environment. There are policies, the ECL itself, this Article 23, is embedded in a larger statute. That statute's policy is protection of the environment. So simply there are all sorts of conflicting policies out there. The program bill that Mr. West cited here was a program bill for another bill. It was similar to the law that was actually enacted, but it was not the bill that was enacted. And furthermore, all that language says, again, is that communities can't regulate. We agree, you can't regulate, but land use prohibitions and land use decisions are not regulations of industry. And furthermore, the idea that, I've lost my thought, on waste. Waste and the discussions of correlative rights and promotion of indigenous resources, the whole concept of waste comes up in the fact that drillers are limited in the number of wells they can drill. And waste is saying that, and industry challenged these in New York and other places, saying you can't tell us we can only drill one well every 640 acres or 40 acres. Or if we want to put in 5 wells, we should get to do that. And the state said, no, we have the right to tell you that you can only drill 1 well every 40 acres, and that's going to be, we're doing that in order to limit waste, because we think when you drill too many wells, there's a problem. So waste is a concept that limits the number of wells that can be drilled. Waste as a concept does not expand the number of wells that can be drilled. There is no policy in this state that we're going to go out and we're going to start at one end of the state to the other and we're just going to force everything. Why even have compulsory integration? You could just say we're going to mandate drilling across the state. We're going to set up a patchwork and we're going to start at one end and we're going to go this way, or we're going to start here and we're going to go up. The state doesn't do that. I can go out and enter into leases and never drill. I can get a drilling permit and never drill. And there is no policy in the state that forces anyone to drill. So to the extent that industry doesn't, the fact that we want to promote indigenous resources doesn't mean that if you enter into leases you have some obligation to drill. It doesn't mean people have an obligation to lease. It doesn't mean that even if you go out and get a permit that you have to use it. So there seems to me to be no persuasive argument that this concept of waste, that once you drill a well, once you've found a place where a well, you both have leases and permission from the state to drill, and it's not inconsistent with community decisions, then you have to limit waste. But that doesn't mean you have to go out and drill willy-nilly all over the entire state. That's not what the concept of waste is about. It's turning the concept of waste on its head. So we think that as a whole, that industry's arguments are not persuasive. The communities do have this right to use their land use powers to prohibit drilling, and that communities should make their own decisions about what they want to do or not. But if they do want to proceed in that course of business and undertake to do that, we've advocated for and support communities' rights to do that.